You're welcome back. This is Newsfile, and my guests have been Abdul Malik Kubako, editor-in-chief of the New Crusading Guy newspaper. News of Husseini is the Honorable MP for Tamale Central. Seth Kwame Champong is the Honorable MP for Mpraeso and chairs the Defense Committee on Parliament. James Agaga is a ranking member of that committee. He's the MP for Bulsa North. We sat in the same classroom, and we used to not to be happy to see the two of us doing prep at the same time and not running at the same times, because you're envious. You don't want him to get the grades. Right. Okay, so here it's the turn for James to also make your presentation to us on the points that you have to canvass, and I've seen you have written profusely. And we ended on a note where Kwekubako indicated to our viewers and listeners that you cannot have a military base. The US cannot have a military base unless with the clear authorization of Congress. You say he may be wrong. How exactly?
Something quite clearly. The United States, like Ghana, is a dualist state. I mean,
when you say dualist states, lawyers, what do you mean by
I mean, in public international law, a dualist state is one which goes into international treaties agreements, but the effect of those treaties and agreements executed would not have any binding effect or force of law unless and until the legislature ratifies them.
Okay.
I mean, that is in consonance with the spirit of
as against money states.
But for the monist countries, once the ratification at the executive level is done, I mean, immediately it is law.
Okay.
So that distinction needs to be drawn. And so Kweku's argument that the US cannot establish a military base unless there is congressional approval could well be the case, because this agreement has to be executed first to give Congress the power to now authorize the establishment, construction of the military base that we are very much afraid of and apprehensive about.
All right. So
something. Having said that, I want to proceed on the basis of Article 73 in making my submissions, and 73 reads as follows.
You are reading the Constitution of Ghana.
That's right, Article 73. The government of Ghana shall conduct its international affairs in consonance with the accepted principles of public international law and diplomacy in a manner consistent with the national interest of Ghana. The national interest of Ghana. So we are not being mischievous here. We are particular about our national interest. Having said that, Samson, we are not targeting the United States because we have considered that previously we have had military cooperation pacts with them. We have never said so. Our criticisms are directed at our government. The United States is entitled, to pursue its national interest. So once an agreement, an arrangement favors them, it's in their national interest, you can't begrudge them for pursuing those objectives. We are saying that as a country, in the face of the agreement, are our interests being served? And that is why we have criticized Nana Addo's government for not serving the best interests of our country. So that is the foundation.
Why is our interest not being served? Show us.
Yes, I'm going to demonstrate that in a moment. Something. First of all, I need to distinguish between a cross-servicing agreement from the instant one, because it's important. Particular provisions in this compare same with what is contained in the 2018 Enhanced Military Cooperation Agreement. That is a fundamental error, and I want to point it out. Let us look at the object of the cross-servicing agreement 2015. And when we do that, you would come to the conclusion that no comparisons ought to be made the way we have so far proceeded. I'll take you to Article 3.3. I want to read for the avoidance of doubt. all activities of parties under this agreement and any implementing arrangement shall be carried out in accordance with their respective national laws and regulations. All obligations of the parties under this agreement and any associated implementing arrangement shall be subject to the availability of funds for such purposes. Unless otherwise agreed in advance, a party shall not place an order and receive support under this agreement and any associated implementing arrangement unless it has funds into brackets or agreed upon in kind support available to pay for such support. If a party discovers that it does not have the funds to fulfill its obligations, it shall notify the other party, which shall have the right to discontinue its provision of any support that was to be paid for with such funds. This shall not affect the... Sorry. I want to make a distinction. This shall not affect the obligation of a party to pay for support already received. The point I'm making is that if you read the trail like I have done, you will realize that this was a commercial agreement.
It's a logistics.
It is support.
Yes.
So you support logistics, it could be spare parts, etc. for money. It is a commercial agreement.
Yes.
So point I'm making is that this particular agreement is different in material respect.
And should not be compared
and
with
should
the
not be compared with the 2018. Everything that was conceived under this agreement was supposed to be done for money, for economic gain. Absolutely. So Ghana would pay for hosting Americans here after they having supplied them with spare parts. Of course, you need them to come and train or sold equipment, certain category of military equipment.
You get the
right? Yes, so that you train our forces as to how to use those equipment and facilities.
And they didn't bring
for money, for pay. That is why the agreement specifically excludes chemical weapons, etc., that those ones could not be transferred.
Yes.
So if you understand the context,
we're not prepared to use chemical
absolutely,
weapons.
if you understand the context of this agreement, it will be fundamentally wrong to strike the kinds of comparisons that we have attempted to do. Senior, let me. So the point I'm making is that any reliance on this agreement to justify the 2018 agreement is much ado about nothing. That explains why even in the memorandum that was brought before us, they actually did not make any serious references to that particular agreement. They sought refuge under the 98 agreement. And we're saying that the 98 agreement has not got an Article 5, which purports to grant unimpeded access, etc. It has not got that. The 98 agreement does not confer exclusive rights to the use of agreed facilities. So under the 1998 agreement, we had access, the opportunity to inspect. In fact, whenever their forces came in here to train with us,
98?
they did that under the full watch and control of our forces. Now let me proceed further. I listened to my brother, my own chairman, Honorable Seta Champong, argue strenuously that as far back as 2015, 2016, thereabout, this particular agreement came before the NDC government, the John Mahama-led government.
Yeah, it's true.
And that they were correct. Yes, that is true. That is true. But the fundamental issue is that we refused. We refused.
There was no agreement.
We refused to pursue it because we thought it didn't serve our interest. So if you now refer to correspondence, look at, yes, we looked at them. The minister conceded, he confessed, he told us that as far back as December 2015, this agreement came before his ministry. Why didn't we pursue it? Because we thought it didn't serve our best interest. So any reference to documentation relating to that draft agreement,
the evidence of the
that draft agreement which came before us will not support the passage of the agreement now under an NPP government.
Okay.
Because we didn't pursue it.
Sorry, even though he will take his stand,
yes,
and also try to react to some of the points you make, I think there's a point that we may need to settle before we proceed.
Okay.
Of the question that you said, whatever they brought under the 1998 8 agreement was under supervision.
Yeah.
And there was no exclusive usage
there was
of
no
anything.
Article 5, yes.
Okay, there's no Article 5.
Sure. Unimpeded access, exclusive use, and I'll come to the specific article and draw the distinction.
But different agreements.
Yes. What I'm holding here, the embassy further proposes that such personnel be authorized to wear uniforms while performing official duties and to carry arms while on duty, if authorized to do so by their orders, and that the government of Ghana accord duty-free importation and exportation as well as exemption from internal taxation on products, property, material, and equipment imported into or acquired in Ghana by the United States government in connection with their official activities. Vehicles, now note, vehicles, vessels, and aircraft owned or operated by or exclusively for the U.S. Armed Forces shall not be subject to the payment of landing or port fees, pilotage charges, navigation or overflight charges, or light and harbor dues while in Ghana. However, the United States Armed Forces shall pay reasonable charges and so on.
Yes.
Is there not a suggestion?
Yeah.
It says vehicles, vessels, and aircraft owned or operated by the U.S. exclusively.
Yeah.
Exclusively.
Yes.
So does that not say to you that there was an exclusive use
of vehicles?
Okay.
Yes.
But not your thing is about the facility.
Absolutely.
As in the building.
Absolutely.
Okay.
And that is where the issue of base comes about.
Okay.
And I'll soon avert my mind to the issue of base.
Yeah.
So the point I'm simply trying to make is that under the 98 agreement, you didn't have an Article 5.4 which reads as follows: United States Forces.
Article.
Yeah, it didn't, but by inference. United States Forces are hereby authorized to control entry to agreed facilities and areas that have been provided for exclusive use by United States Forces, and to coordinate entry with the authorities of Ghana at agreed facilities and areas provided for joint use by United States Forces and Ghana. So you see, even the 4 has 2 parts. The first part is in reference to where the United States Armed Forces have exclusive use, and the second part relates to the situation where the facilities are provided for joint use. So we don't need to confuse the two. The 4 is in 2 parts. But Samson, let me take us back to what would constitute a military base and justify that under Article 5, that what they intend to do is to establish a military base. I just take you through a simple definition, and that is coming from Wikipedia, which says, no, please. A military base is a facility directly owned and operated by or for the military or one of its branches that shelters military equipment and personnel and facilities and facilitates training and operations. It goes on. A military base provides accommodation for one or more units, but it may also be used as a command center, training ground, or proving ground. In most cases, military bases rely on outside help to operate. Now, let us relate this to this particular agreement. First question is, will the United States military directly own and operate facilities within Ghana? Yes. Reference, one of the articles talks about title.
Property.
Yeah, to property that will vest in the United States Armed Forces upon the coming into force of this particular agreement. No, it is there. Is it Article 6? Good. But because of my constraints with time, I'll proceed. Second question is, will they be permitted to train and carry out operations from those facilities? Yes. Then it goes on and on. But let me take you specifically to the case of the Philippines to underscore the point that I'm trying to make. And there's a report. No, sorry.
We'll get to it. We'll get to it.
Go on. I'm taking us to the Philippines, and this is a report. This is a report from Reuters, and I'll read for purposes of clarity. It reads, the United States will upgrade and build facilities on Philippine military bases this year, Manila's defense minister said on Thursday, bolstering an alliance strained by President Rodrigo Duterte's opposition to a U.S. troops presence. The Pentagon gave the green light to start this work as part of an enhanced defense cooperation agreement, EDCA, a 2014 pact that Duterte has threatened to scrap during barrages of hostility towards the former colonial power. EDCA is still on. The defense is now it goes on. EDCA allows the expansion of rotational deployment of U.S. ships, aircraft. U.S. ships, aircraft, and troops at 5 bases in the Philippines, as well as the storage of equipment for humanitarian and maritime security operations. This is the Philippines, where massive demonstrations have been staged against the violation of the rights of their citizens as a result of the presence of United States forces in their country.
Relevance.
So relevance is that in the case of the Philippines, everybody knows, it is generally agreed that those are bases because in your own words, Congress approved of them. We are at the incipient stages. We are now attempting to put the pact together. And I'm saying that once we do that, remember that under the agreement there is room for construction once the agreement comes into operation. So whatever has been provided, they have every right to construct and to improve
They
upon.
cannot go beyond
But,
that area.
but you understand, when you refer to Article 6, you understand that Article 6 is titled Property Ownership.
Thank you.
Yes.
And 6.1 and 6.2 does not vest property ownership in the United States of America.
Thank you.
It may be clause 3
Yes.
And
of
even
that
there,
article.
it's not.
It says United States forces and United States contractors shall retain title to all equipment, material, supplies, relocatable structures, and other movable property that have been imported into or acquired within the territory of Ghanaian connection with this agreement.
Voila.
So the building is not relocatable.
Voila.
So title will not be in the United States.
Read one.
One says
read
all existing buildings,
Yes.
non-relocatable structures,
Yes.
and assemblies are fixed
Yes.
to the land in agreed facilities and areas,
Yes.
including ones altered or improved
Yes.
by the United States forces,
Yes.
remain the property
Thank
of
you.
Ghana.
Yes.
Title.
Buildings constructed by United States forces shall become the property of Ghana
Yes.
once constructed,
Yes.
but shall be used by United States forces until no longer needed by United
That's
States
not
forces.
title.
Good.
Right.
Samson.
That's not title.
Samson, you see
Not
Samson,
title.
that takes us to land law.
That's not
When
title.
we talk about title to property, there are various levels. Even a tenant has an interest.
Oh, come on, I'm not a lawyer. You
Some
the
form
lawyer,
of
see
title
it.
within a fixed period. Now, in the case of the Philippines that I have referenced, the United States government pays rents, and so they don't have absolute ownership of over land or the immovable property.
Doesn't it
Even
look
in our own country.
by the tenor of Article 6?
Yes,
Sorry.
yes.
By the tenor of Article 6, both clauses 1, 2, and 3. Is it not clear to you that if it sounds like a leasehold of sort, and that because look from clause 1, it's categorical.
That's right.
That even if they construct, title remains in Ghana.
Yes.
Thank you.
Then 2 comes to reaffirm that point. Then in clause 3, it says that they have title to relocatable property.
Yes.
A building will not be one that they can take away.
Samson, let me read this. That is 6.1. Buildings, and I'm reading from line 3. Buildings constructed by the United States forces shall become the property of Ghana.
Yes.
Once constructed, but shall be used by the United States forces. Yes,
different from
until
title.
no longer needed by United States forces.
Usage
The
distinct from
analogy is,
title.
Kweku,
Okay.
the analogy in law is that you own land, you own a house. Per our legal regime,
Now you are
you have a lease of 99 years.
Right.
after the expiration of the 99 years, their laudal title reverts to their laudal honor.
Title.
That is the
I read
sense.
this and I don't see title.
That is the sense.
Doesn't this also point to another thing, which was suggested to be that all the construction they will do will simply be in alteration of property that's already been given to them. It does suggest
who
that
suggested?
it
Because
does suggest
it is in
that
agreement.
they can build a new property
facility.
from scratch
No.
and use until they do not have need for any longer.
Yeah, but who hid that? Nobody hid that. That has always been public. It's in the agreement. It's always
Yeah,
been.
so-
Okay, let him finish. Let him finish.
let me continue.
Can you finish
Yes.
in the next 2 minutes for me?
Good, yes.
Yeah.
So,
This is
Samson,
the lost.
the point,
Do note it. Thank you.
the point I'm making is that if you consider the 2018 agreement in context, it is clear that we've given just too much. And I insist, I want to repeat that the provision on third-party claims, the ouster provision in Article 18, undermines our sovereignty. I will refer you to the Constitution itself, 92, which vests final judicial authority
Article 18.
in our courts.
What happened
18.
there? Settlement of dispute.
Yes.
Just like yours,
Yes.
except this is a better one.
Well, I've distinguished between the two.
No, but
that one
in
was
terms
a
of the
commercial
I agree,
agreement
but in principle,
entered
you
into
ousted. No,
for-
commercial
for-
or
for
non-commercial. The
economic
ousting.
gain.
The emphasis is on the ousting. You are talking
Yes,
of ousting
yes,
of jurisdiction.
yes, yes.
It's in the 2015 one.
Kweku, you see, the point
I
I'm
don't
making
see
is
the
that
way you see, but it is there.
we're talking about the government.
In
We're
his
talking about the
introduction,
government.
He
Please,
accused
please.
people of picking and
Please.
choosing.
Let me have 2 minutes.
Right.
We are dealing with a government which condemned, criticized us for selling Ghana's sovereignty merely because we agreed to host 2 Guantanamo Bay detainees.
I didn't hear
Today,
So deja vu. So deja vu.
we were called incompetent, an incompetent bunch of people. Now you are competent, assuming without admitting that we even made mistakes by going into the
It's the
2015
1998
agreement.
one.
Should you repeat same, given the fact that you claim you are
Good
competent?
question. Good question.
Should we repeat the mistakes
good
of
question.
yesteryear?
It's an
Okay,
Should
so-
we do
so-
that?
so
That
can
is
we-
the fundamental
It's not a
question
good
I want.
question.
Can we
I
hear
want to pose.
Mr. Champon now? Can we hear Mr. Champon now?
Oversimplification. It's not a good question.
Thank you. And you see, I'm reading similar agreements with other, countries, and when you look at the one by the UK and Kenya.
That is a visiting forces agreement.
Yes, a visiting forces
The
agreement.
status of forces agreement.
Of
There are
course.
few distinctions
Of course.
between the two.
The question that has been asked by people that I suspect the president will not classify as reckless and hypocritical and all of that. Isam Kumar was here the first time we looked at this matter, and he asked the question, why the rush? Why put it before Parliament at the late hour and rush through it? Why don't you give opportunity for improvement on it? If the president says he's a consummate Democrat and he wanted this to be put so that there will be access, everybody will get to know it, other than what he claims had happened earlier, why did you put it through a process that they didn't have the opportunity to improve the document? Now, Articles 5 and 6 of the Kenyan document is important to me. I think it would have settled all of these developments. Article 5, implementation. The Kenyan one is a 2016 one. It says, on entry into force of this agreement, both parties shall take appropriate action to designate the other party as a visiting force in accordance with the relevant laws. Ghana, we have the Visiting Forces Act 117. If we had done that, we don't stand these problems. Article 5.2. All activities under this agreement shall be implemented in conformity with the domestic law in force in the host nation. Implementation of some aspects of the agreement may be covered by implementing agreements.
It's the same here. You'll be implementing
The party shall designate an implementing ministry as the focal point of contact to implement this agreement and coordinate the activities referred to hearing, blah, blah, blah. Visiting forces and all of that. Then let me go to 6. 6 says, visiting forces shall be subject to, abide by, and respect the constitution and laws and regulations of the host nation at all times. And the corresponding, clauses speak in similar manner. Why couldn't we allow an improvement that equates something like this? And more importantly, state emphatically in this document that it is not intended to be a military base.
Thank you very much, Samson. I think I'll answer the first part where you said, why did we rush it through? We have a practicing procedure in Parliament. We have a committee called the Business Committee, which arranges business of the House that we do. And when any matter is brought before plenary and we have approved of it, that means we have accepted to work with it. We have the business statement for the week ending Friday, 23rd of March. And in that business statement, we approved of that business statement on the, I don't go by the dates, but what the business statement states is that it's outlined the business of that week. Plenary looked at it, and in that business statement was this very particular agreement. We reserve the right to ask for an amendment of this business statement if we thought that we were rushing that business through Parliament. It is us. That's why we said we are masters of our own rules. We approved this. The moment we approved it, it has become a working document. I was not elected to go to Parliament to go and sit idle. I was elected to go to Parliament to go and work.
You spoke about the Defense Ministry itself having to consult so many aspects within the army and all of that within a long period of time, over a year, before it could take the decision to bring this to Parliament. Why don't you allow the parliamentarians a similar opportunity?
It is not just,
at least
something. It's not just only parliamentarians. It's not just only parliamentarians that we had to consult. We had to consult with the military officers themselves, who did back and forth with their counterparts in the US. I, in person, went to the Attorney General's office because it is incumbent upon me, the chairman, to make sure I do solid consultation. And I took it to the Aegis department, and they told me, we've perused this, it's a standard agreement, go and work with it. And this is
my question is, why don't you allow the MPs a similar opportunity?
The MPs had the opportunity in the business statement. If they felt the business was being rushed, they rise up when business statement is read on the House floor and ensure that what they want is inserted.
Why do you table it within a week that you are rising?
Samson, I am not a member of the business committee. The leadership who sat in business committee, who started this whole crusade of majority-minority decision, sat in business committee and accepted it and brought it to us.
Okay.
Extended leadership to work with.
All right.
I couldn't just take it anywhere. So I had to work with it.
We need to clear it. The business committee just programs business. At the time that you were approving this business committee, you didn't know the nature and form of the agreement. So how could you say that the agreement be deferred? You didn't know. They were telling you that the following week an agreement will be laid.
Honorable.
On the so how can we argue that
Honorable, you are a senior member of Parliament. You understand how our workings in Parliament.
I'm just saying that this argument doesn't
nothing is sprung on us as a surprise. How? It's only when we want to come to plenary and play up. Let me down.
Okay, so he's made his point. So let's go.
Very good. The second portion is about the Kenyan
example I raised.
UK that you raised. That is also tailored in another specificity. It's a visiting forces agreement. This is a cooperation, status of forces cooperation between Ghana and the United States.
We have said here on this table, Isankuma has emphasized, and Akufo-Addo referred to not too long ago, that our law, the Visiting Forces Act, is applicable, and international law is also applicable to this,
unfortunately
to the 2018, and therefore there are things that we don't have to worry about.
Unfortunately for me, what happened in my committee, I can't say it all here.
Okay, please go ahead.
Now, the panel that appeared before me from the military had Brigadier General Fiao, who is a PhD holder in law, and my colleagues had a field day to query on every single article. We sat in committee for more than 8 hours. We started at 10:15. We ended after 8:30. All of us, and I must say this, that I congratulate my colleagues on the minority who endured my pressure on them to stay. I must say pressure because we had to encourage ourselves. We consulted to ensure we worked. And at a point in time, they wanted to just leave and go. I said, no, this is national business. Let's get it done. And they endured and we worked together. And I thank them for doing that with us. Now, going forward, we asked about everything, and to a point, we said the meeting was going to be held in camera because some of the points, if I looked at it from my lenses, ordinarily, I do not and I will not have endorsed it. But upon hearing from the military officers who sat and drafted this agreement for us and who were going to use it as an operational agreement, they explained matters to us. There's something they call interoperability in these works. Ghana is a known United Nations contributing nation, and we work with these nations elsewhere. We do not manufacture any weapon. Over 70% of our military generals and officers were trained highly in the United States. We've had this long-standing relationship. It is nothing new. They gave us all the explanations that we needed to know why they ended up with this agreement before us. And they made it categorically clear to us that, please, this is what we've been able to arrive at. And then we asked, did you advert the Attorney General Department when you were doing this? Because we have all the laws. 117, like you said, it was said in committee. They defended it by themselves and said, we've done this over the period, and this is how we do it. This is how we want it done. That is why I started my submission in this meeting, that this is a specific arrangement, an agreement under the military operations. It is a military agreement. So sometimes when we pick it up and then we just oppose it to ordinariness, yes, we will push it somewhere because it does not situate with what we have as experience, what we know in experience.
Right.
So Samson, moving on, I want to say this, that matter of execution that has been raised is a constitutional matter. Parliament, in responding to the executive, and I want to read the parliamentary transmittal, paragraph 1 says that, by the provisions of Article 75 of the Constitution, any treaty, agreement, or convention executed by or under the authority of the President in the name of Ghana is subject to ratification either by an act of Parliament or by resolution of Parliament, supported by the votes of more than 1/2 of all the members of Parliament. The cabinet transmittal came from who? The office of the President. It did not come from my office as a member of Parliament of Christ. So it is under the authority of the Executive President of the Republic of Ghana. And if you go into Article 58.2, 58.2 will tell you, the executive authority of Ghana shall extend to the execution and maintenance of this Constitution and all laws made under or continued in force by this Constitution. It is not me. The President used his subordinate, the Minister of Defense, as the Constitution describes, to act in his stead. And it came to us. My brother James raised this matter forcefully in committee. It was a hustle for over 45 minutes. We couldn't come to a stalemate. Then I said, James, but looking at the documents before us, the biggest of it all is coming from the presidency. And we, by the principle of separation of powers, we are the legislature. The executive is communicating to us. We have to look at what the executive is saying. And so we work with it. So the matter of execution, it doesn't come at all. There's precedence. Honorable Fuseni will know. James might not know. STS, which the Parliament of Ghana approved, the Hansard will prove me right or wrong, had not been executed, had not been signed. Yet the Parliament of Ghana...
That's a loan agreement.
That doesn't make it...
That's a loan agreement.
Beautiful, beautiful, beautiful,
beautiful.
The point is made. The point is made. Allow him to proceed. Good. Thank you. Thank you.
It's a procedural matter.
Thank you.
It's not constitutional. It's a procedural matter.
Go ahead.
It's a procedural matter.
Go ahead.
No. It's a procedural matter.
Proceed. Don't be drawn back. Don't be drawn back. Please proceed. Don't be drawn back. Proceed.
Thank you very much.
Right.
Samson, captured under Article 17 of this very current agreement, it says in 1, implementation. And implementation runs through. 2015 has got implementation. It says the parties or their executive agents may enter into implementing arrangements.
Sure.
To carry out the provisions of this agreement.
May enter.
May.
But they will form the committee.
But at the end of the day, 2 is telling me that the parties hereby establish a joint committee to oversee implementation of this agreement.
That's right.
Okay.
The joint committee shall be co-chaired by the representatives of the executive agents and shall convene as necessary.
Right.
Yes.
Kwaku has read a couple of communications to us. Why those things emanate, why they appear in this very agreement. Earlier on, you asked me about why we didn't put all the benefits in it. I just explained interoperability. Another benefit that I know we'll get, when they are here in Ghana, they will not import water from America. They will buy from the ordinary street person.
Who says?
When they go to Achiasi,
You are saying, Chairman,
when they go to Achiasi, if they want to buy, they want to eat orange. They will eat orange from Achiasi. The ordinary market person in Achiasi will benefit. For me, these are the indirect benefits that Ghana gets out of this arrangement. In Parliament, nobody mentioned to me, and my ranking member is here. I don't know of the $20 million. It never came before me.
Okay.
I only subsequently read about it in the media. Just like my colleague James read about the Philippines agreement, which is coming from a politician like myself, a minister, like him, a former minister. So some of these things, I want to beg all of us in this engagement. Let us be truthful to ourselves. My colleagues are saying that we are offering the base. If indeed we are offering the base, the annex, what it is annex what?
Annex A.
The annex A is in use and has been in use for the last 5
Not
years.
exclusive use.
Let me tell you, you are saying not exclusive use. It's as simple as this.
There are no
You
right
visit
to construct.
me in my home in Kwo. You come to spend Easter with me.
home.
I give you a room to sleep in. And when you are sleeping in the room in the night, and you could demonstrably come in and open the door, would that have been fair to you, or would have been a breach of trust and faith? So this is just a simple analogy of what we are discussing here.
In fact, when you simply rent out, you can't do that. You don't have a right to do that.
Thank you very much.
But this
Thank you
is
very
related
Go ahead.
to
Let him continue.
I
was the first silent person
Let him
here in this
continue. He hasn't finished his point yet. You will have don't worry about that. You'll have some little opportunity of because I noted that you noted down something you needed to say. We'll take care of that.
Samson, there is nowhere in this agreement, and I dare challenge anybody to carry this agreement, that it frowns against any law of our land. We should take it to court. Let the Supreme Court rule.
Two persons have already taken it to court.
And the president has been very democratic. It hurts me when they say he's been not democratic. He's been very democratic in this matter. The reasons are that he has enforced a ruling by our superior court. He has respected a ruling by our superior court. And as such, it has enshrined the strength and the deepening of our democracy.
What do you say about this? That particular ruling on the Gitmo 2 was not that useful, and it will not serve us well. There were those who were against it, including Kwame Akufo at the time, Kwame Boafo Akufo at the time, that for the Supreme Court to have acted as if it is unaware that note verbals could be exchanged between presidents, and by executive authority they could enter into some of these things on behalf of their various countries, was not the best. And this is what they are opening the country to, such that very sensitive matters, and this document that we are dealing with now is marked confidential, and yet now it's all over the place and people have concerns. I have consistently refused to allow for Exhibit A
I agree with you.
to be shown to the public so that people will know the exact locations. Kwame Akufo-Addo, for example, says that by the time that the Supreme Court came round to deliver the Guantanamo Bay judgments, I was of the firm view that His Excellency John Mahama was right about not laying same before Parliament. I made my views clear on this matter. Days down the line, the present military pact with America has stoked the fires. Transparency in a democracy does not mean that we are to lay all documents bordering on national security before Parliament. There is a need to know basis with respect to these matters. A citizen can apply to the Supreme Court to challenge the non-laying of same. The Americans did not debate the dispatch of Osama bin Laden to Congress. The government does not have constitutional authority to breach the national security protocols. Laying such agreement before Parliament is clearly a recipe for putting us in the eye of the storm. It is wrong to lay such agreements before Parliament. The production of documents which will afflict the security of the nation cannot be a subject matter for parliamentary debate. I take my final break. I come to you to state whether or not you think going forward such documents should continue to be put in the public space. Like the president said, as a consummate Democrat, he wanted to put it out there. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis show. And in a minute, strictly, to my question, should these be open for the public as it is?
I just want to reference to the 2015 article 7, which says that security of information. And there it is clear. It says that it is the intent of the parties that activities under this agreement and any implementing arrangements be carried out at the unclassified level. So in security communication, every security communication comes with either secret, restricted, or confidential. It is a standard communication procedure in security world. And that's how it comes. That's why when it came out and people were saying it's a secret document, some of us won't speak to it because that's how we have cited it. And going forward, and that's what we do in Parliament. When there's a matter, because we are reps of the people, so everybody that can know about the matter, we do in-camera hearings and matters are presented before us. This is the first of its kind. It's going forward, it's going to help us shape how we do business in the house.
Okay, but very finally to you, this does not come into effect despite the ratification unless note verbal have been exchanged.
Yes, that's right.
Is there an opportunity to take on board some of the concerns that have been raised in the note verbal, at least?
I'm sure the president is a listening president. The United States has been watching closely and monitoring this. They are good allies of Ghana, and I know they understand. They are doing this with us because of the vibrancy of our democracy.
Okay.
Yes, together we'll sit. If you look at the back and forth that we've done, even at arriving at this, there's nothing beyond us.
Thank you.
Samson,
the secrecy or confidentiality of these documents and the way they are being handled now.
Samson, right now we are bound by the JITMU 2 decision, but you would recall when the decision was handed down by the Supreme Court, I was amongst the first to raise red flags that that decision had the potential to derail the executive's authority to transact business in terms of, I mean, it's right under Article 75 to enter into international engagements.
Right.
Now, our hands are tied. The information that has been leaked and is trending in the public space for me is unacceptable. Look, I've heard some people argue that the previous administration allowed Ghana to be used as a launch pad to do A, B, C, D. I don't want to conclude because I don't share in that.
Guys who said so.
Now, the point is, those comments are injurious to our national
I referred to that last week on this show. Thank you very much. We ought not continue in that vein. Yes, Honorable News of
Something you are which of us? You knew I was going to mention Article 19, and then you put it across. You say Article 19 simply says that this agreement doesn't come into force.
Yeah.
Unless certain things are done.
Yeah, that's right.
And those things are classified under Article 19 as internal procedures.
Exactly.
Yeah. Those internal procedures.
There's no cause for
there's no cause for alarm.
That's why that internal procedures answers to Kuku's question whether there can be a base, because the internal procedures include the Congress of America and ratifying and agreeing that there should be a base.
Okay.
So that's number one. Number two. Quickly. Number 2 seconds. 30 seconds. Number 2. 30
Article
seconds. 5.
You are such a gentleman, please. Don't
Article 5, 5, and 6 must be read together. Because we are granting them those facilities and areas, landed property at no cost. They can develop. So title doesn't rest in them.
Okay.
Title doesn't rest in them.
Thank you.
Title rests in Ghana.
Thank you.
So when they are leaving, they return. Except that where they decide that even those improvement requires that we make some payment, that we'll negotiate with.
Thank you very much, Kweku.
Thank you.
Yeah.
This agreement will come into force when those notes are exchanged.
Notes verbal have been exchanged.
And we'll be sitting in this country waiting to see a base belt. It is a myth.
Okay. It's a myth. Okay. Thank you very much. Thank you very much. And I need to say that I'm proud of my friend Kwame Sefa-Kine, who is donating infant incubators at the Volta Regional Hospital today. Sorry, we couldn't come around to support you, but God bless you for the things that you have been doing under the Kokroko Charities. And Kokroko Charities, you can contribute by dialing 3322 on MTN, 3322 on MTN. Kwame Sefa-Kine, God bless you. He does a lot of that and assisted the Mother and Child Unit that was put up by the First Lady together with multimedia at Akufo-Addo Teaching Hospital. My guests have been Abdul Malik Kubako, Editor-in-Chief of the New Crusading Guide newspaper. Inus Hussaini is Tamale Central MP and Ranking Member Legal and Constitutional Affairs. Seth Kwame Echampong is MP in Praeso and Chairman of the Select Committee on Defense and Interior. James Agalga is MP Bulso North and ranking member of that committee. Thank you all very much for tuning in and for being with us. I suspect that we have been able to canvass the matters in such a way that today we may end the discussion on this. Join Nathaniel Atto on the Joy Sports link today as he delves into the visa racketeering scandal that has rocked Ghana's participation in the ongoing Commonwealth Games in Australia. Thank you very much. I'm Samson Ladia Yanini. My outfit, as always, is by Latida. Have a good afternoon.